we had a couple of bills that we were trying to get enacted. We have run out of time for that, for an independent commission for redistricting, for both the legislative and for the congressional redistricting. So that's no longer an option, no longer possible. The deadline for a constitutional amendment has passed, and there's really no time left to put in place a congressional commission either. So it's still possible for the legislature to pass those bills, but there really isn't enough time to put them into effect. So with that as the reality, we have moved on. We're disappointed, obviously, but we believe that there really are other ways to reform the process without an independent commission. An independent commission is considered the gold standard, but there are lots of other things that we can do to make the process much more responsive, much more transparent, and having criteria that really do make it more difficult to have some of the more egregious gerrymandering that we've seen in Pennsylvania in the past and in other states as well. So House Bill 2638 was introduced by Representative Wendi Thomas at the end of the session just before the summer break and went to the House State Government Committee. An identical bill, Senate Bill 1242, was introduced in the Senate by Senator Tom Killion on July 20th. So, and the idea behind the bill, which we are calling LACRA, the Legislative and Congressional Redistricting Act, is that while legislators' roles in the process will remain unchanged, we can still have a lot of rules that make it harder for them to engage in partisan gerrymandering, and guidelines for courts to test whether maps are fair. So how does LACRA ensure a more fair redistricting process? First, by introducing much more transparency into the process with multiple public hearings and opportunities for the public to be engaged. By imposing specific, clear, measurable map drawing criteria in place of the few very vague standards that now exist. By explicitly prohibiting partisan and racial gerrymandering, and by promoting greater accountability. So again, LACRA does not change the current roles of the General Assembly in redistricting the legislature or congressional seats, but instead it would build upon and improve those existing processes while also limiting the potential for extreme gerrymandering. The bills add qualifications for the chairman of the Legislative Reapportionment Commission. Right now, the commission chair is either chosen by the other four members, which hardly ever happens, or is picked by the Supreme Court, state Supreme Court. And the only requirement is that that person be a citizen and not be a public official. So we would add a number of other qualifications in this bill. For example, no lobbyists, no party operatives, nor their spouses. So a lot of people that we certainly would hope would be disqualified, and which also, by the way, would have been disqualified from our independent commission, would now be disqualified to be the chair of the Legislative Reapportionment Commission. The chairperson would also be subject to Pennsylvania law that applies to financial disclosure and conflicts of interest. The bills also expand the role of an existing arm of the General Assembly, which is the Legislative Data Processing Committee, and that is a body that is made up of the leadership of the legislature, and it oversees the Legislative Data Processing Center. The Legislative Data Processing Center has had an existing role in redistricting for a long time, and they would continue to have that role, but we would expand the functions of that committee and the Data Processing Center to do some other things that are very important. Probably most significant is they would be responsible for maintaining a user-friendly website for dissemination of data, maps, analyses of maps, public comments, and other information that would be, all of which would be free of charge to the public. So that the data processing center would maintain that website for both types of redistricting. LACRA also allows any Pennsylvania resident to submit a proposed map for any or all legislative or congressional districts or parts of districts. And any maps and public comments that come in through the website must be given consideration equal to testimony presented at public hearings. The bills also provide for multiple statewide public hearings, which would be required both before and after the preliminary redistricting plans are approved. This is really a key provision because it provides an opportunity for members of the public to present testimony and information on what they believe to be important communities of interest that should be addressed in the preliminary plan before it's even produced. And then, of course, which should be addressed in the final plan as well. The bills require that final maps have to be published on the website at least 7 days before they are voted on. So this gives the public and mapping experts the opportunity to point out flaws in the proposals before the final vote. So as far as the criteria, that what I just went through is most of the provisions dealing with transparency and engagement of the public. So now moving into the criteria. Under the current law, there are very few criteria that the legislature or the Legislative Reapportionment Commission have to follow in drawing district lines. There is really nothing much more than what's in the Constitution that most of us, I think, are familiar with, which is requirements that districts be compact, that they be contiguous, and that they not divide political subdivisions unless absolutely necessary. So that's the provision that's in the Constitution for legislative districts. Our state Supreme Court adopted those criteria in the court case that applied to congressional redistricting. So they do apply to that as well now as a result of court decision. But there isn't a lot of specificity around those criteria. And as we know, they've been in law for quite a long time, and we still have had some pretty bad gerrymandering that has occurred. So what LACRA would do is provide some additional enforceable limits on splitting of counties beyond what is required by their population. So these are the same restrictions that were in our other bills. So a county could not contain more senatorial or congressional districts than the number required by the county population +1, and no more House districts than the population requires +2. And those are similar to what we've had in our bills for the last few years. In addition, as recommended by the Governor's Redistricting Reform Commission, the LACRA bills also include an explicit prohibition against dividing voting precincts. Also, racial and language minorities would be protected against discrimination in the mapping process. And that would be in addition to any protection that they may have under the Voting Rights Act. LACRA also explicitly prohibits district plans that are designed to protect incumbents or to unfairly discriminate against political parties. So we would have in law for the first time an explicit prohibition against the kind of extreme partisan gerrymandering that we've seen, unfortunately, too often in the past. That then, of course, provides a guideline for the courts to determine whether or not a plan that goes too far and unfairly discriminates against an incumbent or a candidate or a party. So the previous slides, which I don't know whether you're seeing the slides or not, but what I've just discussed identifies what we would call primary rules that apply to all future district maps. But LACRA also includes 3 additional, what we might call secondary mapping criteria. So these would be applied to the extent that they can be without violating the other criteria. So redistricting plans would also be required to keep communities of interest intact, to be responsive to voter preferences as measured by widely accepted tests, and conform district boundaries to natural boundaries like rivers and mountains. So, and the bills contain definitions of those terms: community of interest, which, by the way, cannot include political affiliation. That's not a community of interest. And there are other limitations on what that term entails. And also a definition of what does it mean when we say that a map is responsive. And those things, I believe, will be further explained by our panel from the Princeton Gerrymandering Project.